My name is Captain Kayla Paisley, and I am one of the legal assistance attorneys here at ASG Kuwait. I am one of 2 attorneys that can specifically help you with your issues related to divorce and separation. Welcome to the ASG Kuwait Legal Assistance Family Law Brief. This brief was created in order to give service members an idea about the process by which they can separate or divorce the spouse that they're currently married to. It's offered in order to answer some of the most common questions soldiers have as they're contemplating going through this process. So hopefully through the viewing of this brief, those questions will be answered. Having viewed this brief, if you have further questions or want specific advice, you can make an appointment with the legal assistance attorneys at our office here in Camp Arifjan, and we can answer specific questions for you. If you have a civilian attorney on the state side, we cannot represent you. So if you have an attorney, please let legal assistance know. We won't be able to assist you unless that civilian attorney in writing releases you to be able to speak with us. We are legal assistance. We are not legal representation. What that means is we cannot represent you in the process of your separation or divorce. We are limited in scope based on our licensure restrictions within our states. For example, we are licensed by specific states to practice law, and we can only practice law in courts in those states. Therefore, because of our role within the Army, we can only provide you assistance. We cannot represent you through the process. So we can help you spot potential issues within your case. We can also give you advice generally about the process of divorce. We can help look at the state statutes where you live to determine whether or not there's a waiting period or what the standards are in that particular jurisdiction. We can also help you find resources within that jurisdiction to process the divorce. What we will discuss today is several things. We're going to talk about what separation is. Separation is a moment in time when you and your spouse have decided not to continue the marriage. We're going to talk about that. We'll talk about the general issues involved in separation and divorce: property, child support, child custody, alimony, also called family support, as well as divorce and annulments. We'll talk about Army Regulation 60899. That's the family support obligation. We're going to talk about what that means as far as your obligations under reg to financially support the spouse and children that you have at home. We'll talk about the process by which you become legally separated, either through a separation agreement or a divorce proceeding in court. And we will also talk about the role a civilian attorney can play in representation for you. So what happens before divorce? At some point in time, you and your spouse have decided to separate. Perhaps you're just considering it, or perhaps one of the 2 of you have spoken those words aloud or through texts that when you get home, you no longer want to be married. So separation generally within the 54 different jurisdictions within the United States, separation generally means physical separation, living apart, with an intent by one or both of the parties not to resume the marital relationship. By the nature of the fact that you are here in Kuwait, unless you are here with your spouse, you are physically separated from your spouse. So that separation element has been met. Then you have to consider, when did that separation occur? When was the moment when one or both of you expressed to the other the desire not to resume the relationship? That's when the separation occurred. In some states, there's a requirement that you live in separate households. Obviously, you living in Kuwait while they remain at your home would qualify as separate households. Other states do not have that requirement. Some states are satisfied if you are staying in a different bedroom within the same house. Some states have a requirement regarding how long you must have been separated before you can seek a divorce. Now, this is state specific. We can speak specifically regarding your state if you seek legal assistance consult. We're going to talk about the family law issues that rise from separation and divorce. We're going to talk about property, child custody and support, alimony or family support, as well as the difference between a divorce and an annulment. Property division generally starts from a presumption of 50-50. Everything that is accrued from the date of the marriage through the date of separation is generally considered marital property. The courts will look at a totality of the circumstances in dividing the property, and there are state-set guidelines as far as property division is concerned. It is important to make the request of the court for property division before the final divorce decree is entered, because you may be precluded from seeking it after. Essentially, when you seek a petition for divorce, you are going to be asking the court for several things. You're asking them for the divorce. If you want them to make a decision regarding property, you're asking for property division. You may be asking them for a ruling regarding child custody and child support, and you may be asking for alimony. Some of those things, such as child support and child custody, the court will always entertain after the divorce decree is finalized, because the court always has an interest in the best interest of the children. So they will always consider those things. Other factors or other requests of the court, such as property division and alimony, cannot be considered after the divorce decree is finalized. So if in your haste to seek a divorce, you do not ask the court for a property division, yet you both own a same vehicle, both of your names are on it with a debt, you are going to continue to own that car with that spouse even after the divorce. So if you have property that needs to be divided, make sure that you handle that through the divorce process so that you can have that clean separation after the divorce is finalized. So how should we divide property? The first step is classifying the property, whether or not it's marital property or separate property. As discussed, marital property is generally considered all property that's accrued between the date of the marriage and the date of separation. It is not determined by whose name is on the property. For example, if you buy a vehicle 2 weeks before you are married with your own funds before the marriage, even if after your marriage you decide to put their name on your vehicle on the title, that will still be considered as separate property because you owned it before. Likewise, if you purchase the vehicle a week after the marriage, that can be considered marital property. There are some exceptions. So separate property, again, is anything owned prior to the marriage, anything that you have inherited from a family member or friend that you are the beneficiary of. For example, if your grandfather dies and leaves you $10,000, that's generally considered your separate property. Also gifts. Likewise, if a sibling gives you a gift of $1,000, that's considered separate property. If they give you a brand new television, also separate property. However, if your spouse gives you a gift, that is generally considered marital property. So the 60-inch television they bought you for Christmas last year, they own half of that. But likewise, you also own half of their jewelry that you bought them for Christmas. Also, anything acquired after separation is also considered separate property. Now, this is important as you consider when your date of separation occurred. For example, if your spouse indicated they wanted to divorce you while you were here and there's an established date of separation, it's likely that the courts will consider all the income you've earned from that date of separation as your separate property, as long as you did not commingle those funds with family property. Essentially, it would be important, if you wanted to make an argument that all your income after that date of separation is your separate property, it would be important that those funds be placed directly into an account in your name alone and that it not be used by the marriage for the benefit of the marriage. Example, with the inherited money from my grandfather. If that $10,000 was placed in a bank account that was solely mine, that was separate and apart from the household funds that was used to pay the bills and the mortgage, etc. And it remained entirely in Captain Paisley's sole ownership in a different bank account. At the time of the divorce, the court will generally consider that my separate property. However, if I inherited that $10,000 from my grandfather and put that in my joint account with my spouse, in which we paid the mortgage and the cell phone bills and our vacations, Even if that bank account never dropped below, say, $20,000, the court will not consider that $10,000 mine because it was used for the benefit of the marriage, and therefore it has become marital property. Retirement is one of the common questions service members have regarding separation and divorce. What is the spouse entitled to as part of the separation? Most jurisdictions consider retirement to be marital property. That includes both military retirement as well as any civilian retirement that you or your spouse has earned during the course of the marriage. Only the portion that accrued during the course of the marriage is considered marital property and divisible by the court. What that means is if, for example, I was married for 10 years and 5 years of that marriage was my time in service. Let's say I continue on in my career and do another 15 years so that I complete my 20. My spouse was only married to me for 5 years of that 20 years. So they are only entitled to 1/4 of my retirement, and they would only be entitled to half of 1/4 of my retirement. Recently, the courts have ruled that they are only entitled to that portion of your retirement which you would have earned had you retired at the rank you were at the date of separation. So for example, in the case where I've been married for 10 years, I've served 5 during the course of the marriage. Let's say I retire as a lieutenant colonel. My ex-husband would only be entitled to a portion of my retirement and that amount that I would have earned if I had retired as a captain. The rationale behind that being that my husband did not help me accrue the rank or attain the rank of lieutenant colonel. He only assisted in me becoming a captain. Therefore, he does not benefit from my future military career where I resulted in retiring as an 05. Disability is not generally considered marital property. So for example, if you retire with 70% disability, the ex-spouse is only going to be entitled to their portion of the retirement of that 30%. Most plans require a court order in order to seek their portion of the retirement. So if the court order is silent on it, generally they will not be entitled to it. You are under no obligation to tell your spouse that they are entitled to a portion of your retirement. So if they do not ask for it, and if they do not have a lawyer, if they have a lawyer, the lawyer will know that you have a retirement and that they are entitled to a portion of it. However, if you are proceeding without an attorney, you are under no obligation to tell them that they are entitled to a portion of that. However, if they know about it and they ask for it, if you do not want to be entangled with them in the future, trying to figure out how much they owe or how much they're entitled to and cutting them a check, you can negotiate this portion of your property division to have them relieve their interest in it. For example, if they have more interest in the Ford F-350 that you guys both own than they do in the future potential of your retirement, you could give up your interest in the F-350 if they gave up their interest in your retirement. And this is a point of negotiation that you will want to consider if you do not want to be entangled with them in the future and you plan on retiring from the military. You may have heard about what's called the 10-year rule. Some soldiers are under the impression that a spouse is only entitled to a portion of their retirement if they've been married for 10 years and that overlaps with 10 years of service. This is a mistake. The 10-year rule only refers to a regulation for DFAS regarding their willingness to pay directly to a spouse. So if there is an overlap of 10 years of marriage and 10 years of service, DFAS will directly pay the ex-spouse if they request. So that request has to be made by the spouse to DFAS. The benefit to you, if there is a 10-year overlap, is that in that case, the payments will be coming directly from DFAS to the ex-spouse, and therefore the tax obligation will directly fall on the spouse. So when DFAS pays the ex-spouse, those records are going to be reported to IRS as income, and that spouse will then have that tax liability. If DFAS pays you your entire retirement and then you pay your portion to the spouse, While legally that spouse may have that tax liability and is required to report that as income, chances are they're not going to do that, and DFAS will have reported the income to you, to IRS, and you will be obligated to pay that. So that is something to consider. We're now going to turn the discussion to children and the roles the court play in separation of the spouses as far as child custody and child support. Child custody, there are two different kinds of custody. First is what's called legal custody, then physical custody. The courts, in establishing custody between parents, use what's considered the best interests of the child standard. Historically, in the last, 40, 50 years, there was a perception that mothers were the presumed caretakers and had a sort of a preference by courts for custody determinations. Historically, before that, in a divorce situation, fathers actually had the preference. But now the courts almost universally have accepted the best interests of the child standard, which requires them to look at a variety of factors to determine what will be best for the children for the long term. The legal custody is the right to be involved in major decisions regarding the children, such as choices of school, religious education, healthcare decisions, relocating to a new state. Most cases are going to award the parents joint legal custody so that both parents have a say in these major life decisions. Physical custody is the determination about where the child spends their time and how much time they spend with each parent. It can be agreed upon by the parties, or it can be determined by the court. And I can't stress this enough. If the parties can cooperate and the parties can agree on a joint custody, the court encourages that kind of cooperation and will always defer it to the parents if they can cooperate. However, if parents cannot cooperate and cannot come to reasonable agreement regarding the custody, the courts will get extremely rigid in their order regarding custody, to the extent that the court order may very well say that from 4 p.m. on the Friday before Christmas break, the father has custody up until noon on Christmas Day, at which point the child will be transferred to the mother at a neutral location, such as Walmart, and the mother will have the child up until school on the Monday following Christmas break. It can be that rigid. Trying to agree with the other parent is paramount. Some of the factors the court considers in the best interest of the child are who is primarily taking care of the child, the different approaches to discipline, work schedules of the parents, and how each parent is able to provide for the emotional, physical, education, religious, and special needs of the child. Non-custodial parents get reasonable visitation rights. This does not apply when there is an abusive past, or a past where the father or mother has no relationship with the child. The courts will, of course, consider that. But the courts, for the most part, believe it's important to maintain a strong relationship with both parents. Visitation can be flexible if the parties agree on the terms. For example, even if the court order establishes a written schedule, such as the mother has custody for Mondays, Wednesdays, and Fridays, if let's say they live in the same town or something. If there is a rigid schedule that's set in writing, the court can also include the language and all other visitation agreed upon by the parents. So as long as the parents continue to cooperate, they can amend that custody agreement amongst themselves. If the parties do not agree, as I said, the court can set extremely rigid custody agreements or custody arrangements that if you fail to follow, you can get in trouble with the court. Now we will talk about child support. There is no set amount for a child based on their age. However, there are state guidelines. There are generally worksheets that each state publishes that you can fill out to determine what your likely child support obligation will be. However, parents may agree upon a reasonable amount. Parents generally, however, cannot waive or be released from their child support obligation. So for example, if a father has primary custody of a child and he tells the mother that he doesn't need any support, that's fine, and he does not need to take the support. However, there may be a circumstance I cannot permanently waive, or the mother cannot permanently waive her obligation. So if the father happens to have to go on to state assistance, for example, the state will then require him to seek child support from the mother. So even though he may have told the mother he didn't need support, there may be circumstances in which he's required to seek that support. And like I said prior, the state always has an interest in the child being cared for and provided for, and therefore can always go in and amend the terms of support and custody. Factors in determining the child support amount can include the incomes of the parents, the child care expenses that the child incurs based on their age and needs, medical insurance, standard of living of the child, as well as child's reasonable needs related to education, social, physical, and special needs. Relating to the medical insurance, generally, if you're in the military, the child is covered under TRICARE. If you're in the reserves and the child is on Reserve Select, the courts will take that into consideration and make an order that the child remains, that the service member provide medical insurance for that child. The court is not concerned about the individual bills that you may have accrued. They don't care about your car payments for your brand new Dodge Charger. They are concerned about meeting the needs of the child. So those obligations regarding child support are of the primary concern, and you're going to have to pay those bills first and worry about yourself second. Which state has the jurisdiction or the ability to make a decision regarding your child support or visitation? The legal term is jurisdiction. Essentially, jurisdiction is established by where the child has resided for the last 6 months. So one of the parties or the child must live in the state for that specified amount of time before a court can handle matters relating to that child, custody and visitation and support. So for example, if you and your family were living at Fort Hood prior to your deployment, but shortly thereafter, your spouse moved with the children to Colorado, and they remained in Colorado for the last 8 months of your deployment. When you return and are seeking custody of the children, Colorado is going to have jurisdiction over those matters because that's where the children have resided for the last 6 months. One of the reasons that this jurisdiction regime, has been set up is because courts need to have access to the witnesses who are going to be able to speak to the best interests of the child. For example, teachers and counselors, medical professionals, other people who can enlighten the court regarding the needs of the child and who best can meet those needs. Whichever state establishes jurisdiction, that court will have exclusive ongoing jurisdiction over that matter. So for example, in the situation where the family moved to Colorado and child support and visitation was established in the Colorado court, you will continue to have to go to Colorado to address any changes to that child support or child custody agreement. There are exceptions. If all the parties have left Colorado, they can seek to have the case transferred to a new state. But again, that's going to be at the request of the parties by agreement, and the court will have to do that. We're now going to discuss spousal support, also called alimony. Spousal support is either an amount agreed upon by the parties or established by court order to be paid from one spouse to another. In recent times, with the increase in dual incomes, courts have moved away from awarding alimony. Generally, if a household is a two-income household, courts determine that both parents or both parties are able to meet their own needs and do not require one spouse to pay the other. However, there are situations where courts do award spousal support. It can be required to be paid during separation and or after the divorce. Generally, it's set for a specific amount of time. This is another thing that must be set by the court before the divorce is finalized. If neither party seeks it in their petition for divorce or in their answer to the divorce, and the divorce is finalized, the spouse cannot come back after and request spousal support. They will have waived that opportunity. Again, it's often limited in time and amount and can terminate when there is dramatic change in circumstances. So the award is at the discretion of the court, and it depends on factors like the needs of the spouse, the education of the spouse, the standard of living, the length of the marriage, and or the occupation of the spouse during the marriage. For example, if two lovebirds marry in college, and one has aspirations of becoming a doctor, and the other spouse supports that decision and goes to work immediately to support the family during the other spouse's education to become a doctor. If that spouse becomes a doctor, essentially by being supported by their spouse for that entire, essentially 8 to 10 year process, and then decides they want to divorce the supporting spouse, the court is going to take a very firm view of that spouse and tell them that they are required to pay spousal support to the sport that supported them through that process. Again, it's an issue of fairness, and the court's taking into consideration that totality of the circumstances. One thing that trips people up here is that it's the standard of living that was established during the course of the marriage, regardless of whether or not you were supportive of that expense. So for example, if your spouse chose to get their hair dyed and their nails done every week for a cost of $200 a week, and throughout the entire course of your marriage you objected to that expense and you felt that it was frivolous, when the court goes to establish what the standard of living was during the course of the marriage and dividing up what those costs are, that is going to be a valid expense within the marriage to be considered in determining that totality of the circumstances and standard of living moving forward. Now, that's not to mean that the court, that spouse would absolutely have the right to, continue to do that practice. The court recognizes that if it's a one-income home supporting, at the time, one household, but now that one income has to support two households, the standard of living for both parties obviously will have to diminish. But that is one of the factors that they'll consider. One party may be able to request a change to the support if there's a significant modification, and it will also generally terminate should the supported spouse become remarried. Are dependents covered under TRICARE during the separation? Generally, yes. Any of your natural children will continue to receive TRICARE benefits before, during, and after the divorce until they are legally ineligible, having either attained the age, I'm not sure what the ages are, perhaps 21, perhaps 23 if they are in school. But if your natural children, they will retain their right to be covered under TRICARE regardless of the circumstances of the divorce. Spouses and stepchildren, if they are DEERS enrolled, are allowed to continue with TRICARE coverage up until the divorce is finalized. After the divorce, a spouse is only covered by TRICARE if there's a 20-year service plus a 20-year marriage with at least 15 years of overlap. Then they are entitled to 1 year of TRICARE coverage. If there is 20 years of service, 20 years of marriage, and a 20-year overlap, that ex-spouse will be entitled to TRICARE for life. We are now going to discuss Army Regulation 608-99, which outlines the service member's obligation to support their family financially. Essentially, this regulation determines when physically separated from their spouse what the obligation is for the service member to pay to the supported spouse. Absent a court order or an agreement between the parties, this regulation dictates the specific amount you owe your family based on your rank. Now, if there's an oral agreement between the parties, the military is not interested in getting involved in that. So if there is an oral agreement between the parties regarding how much support you'll give, and both parties are satisfied with that, nobody within command is going to have a problem with that. Soldiers are presumed to be meeting their obligation absent a complaint by the family member. If there's a complaint by the family member that they are not being supported, they will bring that to command, and you can be counseled if you have not been meeting your family support. You cannot be required to pay the former amount that you needed to pay. You can only be ordered to make payments moving forward. However, if you fail to do that, then you can be in trouble for violating a direct order. But that specific amount that you owe, again, absent a court order or an agreement between the parties, is established by the BAH non-locality rate, also called BAH2 with dependents. It's a specific chart that we have in our office and that should have been provided to you when you found out about this brief that outlines what the obligation is. The service member's financial support obligation starts automatically at the date of separation. So that's why it's important to clearly establish what that date of separation is. The obligation ends if there is a separation agreement or a court order which addresses support, or upon a finalized divorce. If the non-service member's spouse is in government housing, then the service member's obligation is satisfied. Dual military spouses have a different obligation, and if you're dual military, we can answer what that obligation is. So how much support is required? So the chart establishes what the amount is. So for example, an E5 would owe their spouse $941.70. I'm going to hold up the chart. Essentially, you find your rank on this column, you move over to the with dependents column, and that's the amount that you owe. Now that's the presumed amount that you owe to all dependents that you have. So for example, if my husband and I have 2 children, but I also have a 3rd child with a separated spouse, a divorced spouse, and I pay child support for that child, my husband and the 2 children are entitled to 3/4 of this amount because there are 4 dependents that I have. So if you have children outside of the current marriage, you will want to discuss with us what your obligation is to your current spouse. The total amount is due by the service member on the 1st of each month. The service member can pay either through allotment, check, money order, electronic fund transfer. It is recommended that you do not pay by cash unless your spouse is willing to give you a receipt, which is unlikely, because you need to retain proof that you have met this obligation. Again, if a complaint is made, you will need to be able to provide proof to your command that you have been meeting this obligation. Service members can meet their obligation through what's called in-kind payments. An equal amount of a rent or mortgage for the home where the spouse currently resides counts towards your obligation. Also, payment of essential utilities for that home, such as gas, water, and power, also are considered in-kind payments to meet that support obligation. So for example, if under the chart I owe $1,200 to my husband, but I am currently paying the rent for my apartment, which costs $1,300, that is considered having met my support obligation. Now, if I have a lease for that apartment and owe $1,300 every month, which I continue to pay, and my husband has left that home, I now owe $1,300 to maintain my mortgage or my lease, and I still owe him the $1,200 support obligation. You do not get credit for payments for other things other than the essential utilities. So for example, car insurance, cell phone bills, internet, none of those count towards your family support obligation. And we can discuss in detail what payments you have that may be considered in-kind payments for your support obligation. Waiver of your 608.99 obligation is extremely limited. A service member may be eligible to have their obligation waived in certain circumstances. If there's spousal abuse that's documented, if the income of the spouse exceeds that of the service member, and there's proof that that income exceeds their income, then they could be waived. The supported family member is incarcerated. The support has been provided for 18 months. If you have been separated from your spouse and have been paying this obligation for 18 months and the divorce is not finalized, the battalion commander can release you from that obligation. Or if the child is with an unlawful custodian. So those are the enumerated ways in which you can be released from that obligation by the battalion commander if you show by a preponderance of the evidence that those things have been met. Now, for example, if you know that your spouse makes more money than you and you ask them to provide a W-2 to show your commander that they make more money than you, and they fail to send that to you, command can specifically request that information from them. And if they fail to provide it to the command can still waive your obligation. So if you are in one of those circumstances, please speak to a legal assistance attorney and we can work with you to try and see whether or not a waiver is appropriate. The SPCMCA, which is generally an 06 command or higher, may be also able to release you from an obligation for fundamental fairness. And again, that will be a very fact-specific discussion that you would need to have with a legal assistance attorney. And the waiver must be authorized in writing by that battalion commander or SPCMCA, and they have their own obligation to do a legal review to determine whether or not it is appropriate under the reg. We'll now talk about the process of obtaining the divorce. How do I go about doing this? Many states are what are called no-fault divorces. Essentially, it does not require one party to have caused misconduct or committed misconduct or done anything to result in the separation and the divorce. As long as there is irreconcilable differences and the parties cannot resume the marriage, the states will grant the divorce. Residency is required. This is like the jurisdiction regarding the child support. So one party must be a resident of the state where you are asking for divorce. State law dictates whether you are a resident and usually requires you to live there for a specified period of time. This is not your home of record and it's not necessarily where the marriage occurred. Again, it's where the parties reside. So for example, if you deployed from Fort Hood, Texas, Bell County will have jurisdiction to determine your divorce. If the spouse moves to a different state, that state may have jurisdiction to grant the divorce. If you seek and go through the divorce process without an attorney, that's called a pro se divorce. It means without an attorney, doing it on your own. If you seek a pro se divorce, you must still meet the residency requirements and the other requirements under the law in order to obtain the divorce. Pro se divorce is not recommended unless it's been a short-term marriage, there's no property, no children, and again, no significant property to divide. It is still required that you know how to do it and that you follow all the rules of the court. If you believe that a pro se divorce would be appropriate for you, there are often many resources online to help guide you through the process. And a legal assistance attorney can help you review the paperwork to ensure that all of the questions are filled out correctly so that you know the proper steps to obtaining the pro se divorce. Some people want to know whether or not an annulment is appropriate. Annulment is only available in extremely rare circumstances. Bigamy, one of the parties is already married and therefore this marriage is not lawful. This is generally not done out of malice, but rather one of the parties did not successfully get a finalized divorce prior to seeking this marriage. That would be one basis for an annulment. Also, if you determine that you're closely related by blood, for example, you found out you're married to your half-sibling, that would be a basis for an annulment. Mental incapacity, duress or threat of force, significant fraud, or the marriage not being consummated may also be grounds for annulment. But again, factually, these are extremely rare. Annulment says the marriage never existed and you were never married, which means if anybody asked you in the future if you've ever been married, you can say no, single, never married. However, keep in mind that DFAS will find out that you were never married and will seek to recoup any benefit you received from the marriage, because once the marriage has been annulled, they will seek again any BAH with that you obtained during that, any separation pay that you got during the course of that marriage. Once the marriage is annulled, they will seek that money back. And you know the Army is very good at getting their money back. Internet or foreign divorce, just don't do it. The likelihood of a successful divorce being accepted by any jurisdiction or DFAS is extremely unlikely. Foreign divorce, likewise, unless you and your spouse were living in a foreign country when you obtained your marriage, or they're from there and that's where you got married, then a foreign divorce is likely not going to be accepted by the state and by DFAS. All right, so if you are now ready and you want to divorce, how do you make that happen? Well, there's two different routes. You can seek a separation agreement or go to direct court action. So a separation agreement is a contract between the parties that are voluntarily entered upon and signed, again, by both parties. You and your spouse can agree to just about anything in the separation agreement, as long as it's legal. You can establish child support and child custody. You can determine spousal support and alimony, and divide up the property. A separation agreement is generally appropriate if both parties have a clear understanding of what they want and can come to agreeable terms. However, most separation agreements that are drafted on the civilian side have a no interference clause or a dating clause, which says that neither party will interfere with the other party's pursuit of new significant others. However, the inclusion of that clause does not allow a service member to enter into an extramarital affair. Essentially, you are still married, according to the Army, up until the divorce is finalized. So if you seek a relationship outside that marriage, you could be charged with adultery. So keep in mind that you are still married for the Army standards and up until the divorce is finalized. Now, this may be a point of frustration when your civilian spouse is allowed to and does enter into new relationships. But unfortunately, the Army owns you and not your spouse, and they're the ones that dictate that you cannot have an extramarital relationship. A violation of the separation agreement is considered a breach of contract, and relief is sought from the courts through a suit. Third parties, such as creditors, are not bound by the separation agreement. So, for example, if my husband and I have a $10,000 debt that through the separation agreement we agree he is going to pay. Let's say he decides to enter into a new relationship and decides he does not care about his financial obligations and stops paying. Let's say this lifestyle leads him to a bankruptcy where he is then released from the obligations for these debts. If that $10,000 debt had my name on it, I can still be sought for the payment of that entire debt, regardless of the fact that the separation agreement said that he was supposed to pay that. I can then sue him for breach of contract. However, keep in mind that because he sought bankruptcy, he's probably judgment proof and has no money for me to come after. So be aware that and watch your credit report to make sure that your spouse continues to pay the obligations that your name is on, that they've agreed to take through the separation agreement. Should you get a separation agreement? Both parties must agree and cooperate with the process. It's an efficient way to settle your differences without court involvement, and the separation agreement can later be used by the court to set the terms of the divorce. They are sometimes incorporated into this divorce decree, but the terms of the separation agreement are not easily modified, so be careful what you agree to. Consult with a civilian attorney if you have any complex issues, and they can help you facilitate agreement between the parties. They can also help spot trouble areas. Mediation might also help the parties come to an agreement regarding the terms of the separation. Do you need a separation agreement? No, they are not required. They are not necessary to be considered legally separated. Again, separation occurs once the parties are physically separated with an intent not to resume the marriage. However, separation agreements can resolve many, if not all, of the issues pending the divorce, especially helpful in states that have the long waiting period, such as Tennessee. So, for example, if you are in a state that requires a physical separation for an extended period of time, you may seek a separation agreement so that all the matters are established now and both parties are bound by that. And then once you have met that separation requirement, formalizing that through the divorce decree. Court and the litigation that's involved in a court action can become extremely expensive, and the only people who win in a drawn-out custody and divorce disagreement are the divorce attorneys who make money. The court is utilized when the parties cannot agree. It requires court filing and filing fees to begin the process, and can become extremely expensive if the parties, again, are fighting about every issue. You must make a claim for all your issues you want addressed. We talked about that before. In your petition, you're going to seek the divorce, if you want property settlement, if you want the court to address child custody and child support. Essentially, in a contested divorce proceeding, you lose control of your case, and the court will decide what's best, not the parties. Court orders are official rulings by a judge directing a party to do or not do an action. They supersede conflicting terms within the separation agreement, and they usually require attorney representation. If you willfully disobey a court order, you can be found in contempt, can possibly lose custody, you could be arrested, you can lose your licenses, and that's any license the state may give you, such as driving privileges, fishing or hunting licenses. They can seek liens against your property for failing to obey a court order. Essentially, very bad news. Civilian attorneys really can help, and I can't stress this enough. If your spouse seeks attorney representation, you too need to speak to an attorney. Sometimes the benefits to it cannot be stressed enough, because attorneys can help spot the issues, they can simplify complex issues, and make suggestions for negotiation. An investment upfront can save you money and time, because essentially, if you do it yourself and you mess up, attorneys can't help fix it. So again, if your spouse has a divorce or has a divorce attorney, or if you have any complex issues, it's important to speak to a civilian attorney. Generally, each party is responsible for their own attorney's fees. States do have laws that allow some attorney fees in certain cases. You can also work out an agreement if it's going to be a pretty much agreed divorce. However, keep in mind that a lawyer can only represent one party in a proceeding. They cannot represent both parties since they have adverse interests to each other. So while you or your spouse may hire an attorney to do an agreed separation agreement, that attorney will make sure that the non-represented spouse understands that they are not a client and that they should seek legal representation before signing any separation agreement. And if your spouse has retained an attorney and has a separation agreement that they want you to sign, please feel free to make an appointment with a legal assistance attorney who can go through the terms of that and explain that to you. Where do you find a civilian attorney? We are prohibited from referring you to a specific attorney. However, we can provide you information on how to find an attorney in your specific jurisdiction. Do not expect a reduced fee or free services for family law. Some areas of military law, lawyers are willing to provide legal assistance on a reduced rate. That is not generally true for family law. Everybody has to pay for that. And that concludes the family law brief. Thank you for your attention, and we look forward to seeing you in legal assistance. Thank you.